Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorney Nathan Seltzer and our director of litigation, Chance Weldon. We're here ordinarily to bring you Supreme Court cases as they drop this session, but we're coming out of a break in drops from the court. So today we're going to talk about some things that have happened on the court, or around the court rather, the last couple of weeks. The first being Justice Thomas's speech at UT, which we had the honor of being part of and being there to witness in person. And then we're going to talk a little bit about the New York Times article and the Supreme Court leak and the shadow docket. So let's start with Justice Thomas's speech at UT. Chance, I'm just going to ask first impressions. What were your impressions of Justice Thomas's speech? I know I'm
not Chance, but it was based.
Well, I mean, I think context matters. So he was invited to speak on the 250th anniversary of the Declaration of Independence. And so it was really Justice Thomas, in a certain way, at his best, walking through the history of the philosophy of the founding. So he starts and he walks through, both talking about his personal story, but also talking about the principles of the founding and how those have applied through the years, through the country, on the court. He gave examples where the court has failed to live up to those high ideals. And he talked a little bit about, which I think we'll talk about in a minute, the transition that happened in the progressive era. And that's, I think, where a lot of the controversy from the speech stems from, as he walks through sort of a transition in first principles that happens in the early 20th century in the United States. And
he's not the only justice that's going and giving these speeches at academic institutions right now. All of them, I think,
No, it's very common for justices to give these sort of speeches at academic institutions. It's very common for them to talk about things like the Constitution or the Declaration of Independence and broader civic education. So this is not an unusual thing. It was a pleasure to be there to watch it. It was certainly a packed house, but it's not anything unusual.
Nathan, what were your impressions from the justice's speech?
I think that what I want to do is counterbalance what a lot of the media reporting did, which is very hysterical and hyperbolic, and look at when he's speaking, like Chance just explained, he starts with the Declaration and walks us through history, walks us through founding principles, and really sets the stage for the Constitution. Because what some of the critique of his speech has said is that, like, they'll say something like, our rights come from the Constitution. And for Justice Thomas to say something like natural law exists, which he makes an incredibly strong case for in the speech, is you have to just pull parts of his speech out of context. Yeah. And because he already addressed the critique that he's getting. When he talks about the Declaration and we're referencing inalienable rights that are endowed by our Creator, you can't say that, like, and this is in our founding, the thing that separated us from the United Kingdom is the Declaration of Independence. That's the document that created the United States of America as we know it today. And so to say that document isn't relevant, and the only thing that matters is the Constitution, I think is ahistoric.
Yeah. I think it's interesting how, well, let's start here. There's a somewhat modern interpretation of the Declaration of Independence, that the Declaration itself is not law and doesn't have the force of law. Mm-hmm. But as Justice Thomas was speaking, it was very clear that he doesn't just view the Declaration of Independence as law in a sort of a traditional sense, but that he views the Declaration of Independence as the font of our law. It is where our law actually stems from, and the Constitution itself comes from the Declaration of Independence. Is that something that we generally would agree with?
So I think it's interesting. I think that it's important to point out that there are originalists on both sides of this divide. I mean, Justice Scalia and Justice Thomas have historically disagreed about this. Justice Scalia was more, we've used this term before on the show, of a legal positivist, right? He said the law, when you look at the Constitution, it's just the text. He said, the Declaration of Independence is not, in fact, the law. The Constitution is the law. And I think Justice Thomas is making a more nuanced argument that to understand the text of the Constitution, you can't ignore the philosophical points that are made in the Declaration. Right? You have to look at when you're reading something like life, liberty, or property, or when you're reading something like the First Amendment or the Second Amendment, which recognize a pre-existing right, to understand what that is, or the Ninth Amendment, which talks about pre-existing unenumerated rights. you have to go back to and read in context with the Declaration of Independence. And this has been a dispute amongst originalists for a long time. The way that you look at the text of the Constitution, do you read, in a certain sense, the Declaration into that text, or do you read that text in the context of the Declaration?
I think it leads to an important question. What did the founders intend for the Declaration to do? Was it simply that legal document severing that relationship that we had with England, or was it supposed to inform our law as it progressed? And does it even matter what the founders actually intended for it to do?
Well, I think if you look at the Ninth Amendment, that does something. It's referring to things outside of the Constitution. And so if we're not supposed to look outside the Constitution, which is what perhaps like some of the scholars that I've read this week have said, that our rights flow from the Constitution, and we can't look outside of it, then what is the purpose? What does the Ninth Amendment do? Because
can we pause on that for a moment? I think it's important to unpack what we're talking about there. This is, the Mother Jones article where they're quoting some academic, and this is something that's actually came up recently. I think someone in the Congress or someone from Virginia had made a similar point, that our rights come from the Constitution, that the government creates our rights, which is a big deal of what Justice Thomas was talking about in his speech, which was that the American founding rejects that notion of rights.
Let me put some details on that. The Mother Jones article that we are referencing, it was titled "Clarence Thomas's Radical Remarks Might Not Be What They Seemed." The author is Pima Levy, and she either interviewed or just quoted a Washington University School of Law professor named Andrea Katz, who says Justice Thomas is engaging in some strong natural law thinking. In fact, it's close to theology on the bench. This critique, that is Justice Thomas's critique, is denying the premise of our written Constitution. Our rights come from our Constitution. They don't come from God. That's the premise of the U.S. Constitution. We have to write down the rights that we have. That's quite a statement from a judge whose job is to enforce the text. So she's coming from, Professor Katz is coming from this position of saying our rights are from the Constitution. We don't have any rights outside of it. There's no higher being. There's no natural law that's giving us these rights. Mm-hmm. The only rights we have are embedded in the Constitution. And you can kind of see where immediately you end up in this tension of, okay, well, if they're just what's in the Constitution, is that really all we have? Or is that really all of the rights that we're entitled to?
I think you have to even, does the text of the Constitution even allow you to have that position?
In what way?
Because the text of the Constitution itself protects a pre-existing right. It doesn't say we're creating this and delineate that right. It says the freedom of religion shall not be infringed.
Right. It doesn't say the people shall have a freedom of religion which shall not be infringed.
Right.
It presupposes.
Exactly. It presupposes that there are these rights, these inalienable rights, or these important rights that existed at the time, that were understood at the time to have certain contours, and then it protects them against government infringement. But it doesn't claim to be creating these rights. The text itself presupposes them. And that's without even looking at something like the Ninth Amendment.
Right. Which doesn't even make sense if you assume that the Constitution brings the rights with it.
Right. The Ninth Amendment explicitly says that there are rights that are unenumerated.
Let me just read the Ninth Amendment. I'm going to read the entire thing right here.
Yeah.
It's going to take so long, though, Nathan.
Just bear with me. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That's it.
And the use of that word retain is so vital to understanding that, because the assumption, the only way that you can read the word retain is to understand that right existed before and it continues after. Right. You had that right beforehand and it continues after. So as we are discussing that the preamble to the Declaration of Independence, and that we are endowed by our Creator with certain unalienable rights, and that among these, not that are limited to or anything of that nature, among these are the rights to life, liberty, and happiness.
Her criticism is also unfounded, I think, in another way, which she talks about this. He's a theologian from the bench sort of argument, and that doesn't make any sense, because we're still looking back at the founding and what the founders envisioned as what our pre-existing rights were. So Justice Thomas is not free and would not consider himself free to like say, oh, God told me about a new right or something like that, which is, that's the implication.
I had a dream the other night. Yeah.
But that's the implication of this critique is like that we're just going to, he's like an Ayatollah or something like that. That's just going to,
I mean, he wouldn't even be free to like bring in like Aquinas or something unless he could tie it in some way to the text, right?
Absolutely.
I mean, yeah.
Which I think during his confirmation hearings, this was a question that was asked, that are you going to rule based on natural rights? And his response to that was, no, I'm bound by the Constitution. But natural rights inform the Constitution, like we just laid out. It's part and parcel to that conversation.
And I think the point that he was making in his speech is that the transition to she's really making his point, because he makes the argument that in the progressive era, the idea that you would have rights that were created by government that didn't have a deeper vesting, and rights that are created by government can be taken away by government, that rights aren't these things that exist independent of the arbitrary whim of the majority or the arbitrary whim of the experts. She's making the exact point that he says progressives make. And I think it's important to pause for a moment and just how bonkers town that position is.
Yeah.
I mean, how radical her position is, which is that you don't hold anything outside of what government decides to give you. That is a radical position.
Well, and it's a position that ultimately is going to lead you to a tyranny of the majority problem,
right,
where it doesn't matter what you think you're entitled to. What matters is what the majority thinks you're entitled to. What matters is what 50% plus one thinks you're entitled to. Whereas our Constitution lives and breathes this theology, if you will, that those rights are ours, and the government only has the power to take from us those rights that we have allowed it to take from us, and for the reasons that we have allowed it to take them from us.
Yeah. I mean, it's a really, I mean, at the 250th anniversary of the Declaration of Independence, she's flatly rejecting the premise of the Declaration of Independence.
Yeah, because it doesn't make any sense that we would split from England if we just didn't like what the government was doing.
But I mean, think about the text of the Declaration. It says, we hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that governments are instituted among men, deriving their powers from the consent of the governed, but they're instituted to protect those inalienable rights that pre-exist government. Yeah. Her argument is that's all hogwash, that's all made up. And tellingly, that's the same argument that was made by John Calhoun, the good old slavery as a positive good, John Calhoun. Oof. That's the same argument that was made by Alexander Stephens in the defense of the Confederacy. So the position that she's taking there is an un-American position with a very bad pedigree.
Yeah.
And so for her to say that Justice Thomas is somehow radical, to simply be quoting the Declaration of Independence, I think it's important to pause and think about that for a moment, how radical it is to say that he's radical to simply quote the Declaration of Independence.
I want to talk a little bit about how that the author of this article frames that exact theory. She says Justice Thomas was talking about a right-wing fringe theory that early 20th century's progressive era ushered in an unconstitutional change in our government that must be rooted out. It's wild to me that she couches that as some sort of like conservative conspiracy theory.
Yeah, history is fringe.
History, not just history, but like the founding itself, the Declaration itself is fringe.
Yeah.
When instead we saw in the 20th century a shift in how we view the Declaration of Independence and how we view the rights of man. Instead of being something that is inherent to man and protected from the government, it's something that's granted by the government and the government can take away on a whim.
Yeah.
That's the fringe theory that ultimately ended up carrying the ship, at least apparently, in where we're standing today.
And I think that's what Justice Thomas, very clearly drew that dichotomy. He said that the progressive era, ushered in by Woodrow Wilson, is incompatible with the Declaration, and that we have both of those currents in our society right now. We have the rights, the unalienable rights endowed by our Creator, and yet we have a simultaneous current of progressives saying that the only rights you have are the ones that are enumerated in the Constitution, and they're given to you by government. And those things are fundamentally incompatible, and they both exist right now. And so I don't think Justice Thomas was crazy to say that. I think it's...
Well, yeah, and historically speaking, there's nothing, you'll note that no one's making critiques of whether or not the things that he said in the speech were historically accurate. Right. I mean, Woodrow Wilson, in his own words, thought that the Constitution was antiquated and outdated and an undue burden on government and government experts being able to do what they want for the good of the people. The folks in the Roosevelt administration, the Franklin Roosevelt administration, were of the same mind. So there's not exactly anything in his speech when he's talking about the history of the progressive movement and the tension that it created with our constitutional order and with the philosophy of the Declaration. No one has argued that those things are untrue. They've pushed back on attacking progressivism, right? Because I think modern progressives, are upset about using that word. But as a historical matter, there's nothing untrue in Justice Thomas's speech about Woodrow Wilson and the early 20th century progressives.
I think tying to that modern progressives in the context of this speech are not really the objective, I don't think, behind what Justice Thomas was saying. He wasn't really talking, and some commentators have ferreted this out a little bit. He wasn't really talking to the modern progressives. He was talking to modern conservatives. Mm-hmm. He was talking to people who pay lip service, at least, to conservatism. To what extent do we as conservatives have an obligation to start dismantling and taking apart these early 20th century doctrines, including federal agencies, including these kind of independent agencies? I say kind of independent because their independence has very much been called into question. Yeah. To what extent do we have a duty to push the legal movement that direction? Does that question even make sense?
Yeah, well, I think it's important to break up two things. One is a political argument and one is just a constitutional, more judicial argument. And I think it's important to recognize that there's a certain, will to power on both sides of the political aisle. Absolutely. And there's a certain, temptation to use government on both sides of the political aisle and to use the administrative state on both sides of the political aisle. And that has to be separate from whether or not that will to power is consistent with the text of the Constitution, is consistent with the founding, and is consistent with the ideas in the Declaration of Independence. And I think the question is, anytime you have that sort of will to power administrative state, government by fiat, government by I'm going to, pursue the common good and, throw away all these procedural checks and balances. It's an easy question. It's an easy conclusion that that's not consistent with the Declaration. That's not consistent with the Constitution. That's not consistent with the founding, whether it's for right-wing ends or left-wing ends. So I think there's a political question and then there's a constitutional question. I think we're more comfortable, talking about just, is this consistent with the text of the Constitution? That's what we do.
Yeah.
Right? And I think that that's an easy question.
I think the question that I'm asking is more pragmatic as we are looking at judicial opinions that are being handed down. Is the right approach, and I may or may not be using this term correctly, is the right approach more Burkean in the let's not take the wheels off the train while we're on it kind of mentality? Yeah. Or is the correct approach more this is incompatible with the Constitution, let's do away with it, and that YOLO originalism kind of standpoint? What would we say is the right approach from a legal perspective?
Well, so I think that's a really fun question because I think you can see it breaking down on the court as it exists right now. There are some members on the court, your Justice Gorsuch's, sometimes your Justice Thomas's, that say that's not a question for the judge.
Yeah.
Like we shouldn't be looking at the downstream consequences of this, and we should go back to an original public meaning of the Constitution and enforce it. And if it creates downstream consequences, that sounds like a you problem.
Maybe right? Congress could do something about this.
Maybe Congress could do something. It's my job as a judge, these justices would say, to look at the law. Yeah. You have others that are more Burkean, right? I mean, Justice Barrett in cases had said, we're not going to move until we have a new doctrine to replace it. This was in some of the cases where she's been hesitant to rule on something, hesitant to take a case unless they've thought through the consequences of how you unwind the old doctrines. And Justice Roberts falls into that category as well. And so I think there's an interesting question of even on the court, how you would answer that question. Are you the YOLO justice, as we've talked about? You only live once for folks that don't know what YOLO means. Or are you taking a more Burkean, Edmund Burke style minimalist, approach?
I think the Second Amendment jurisprudence is really instructive in this discussion because there's no tiers of scrutiny or anything like that in the analysis. The court is really just looking at the text and like what the contours of the right is. So the text of the Second Amendment says the right to bear arms shall not be infringed. And the court looks at our nation's founding and at the passage of the 14th Amendment, what were the contours of that right? Because like everyone agrees that the right to bear arms doesn't mean the right to shoot anyone you want with an arm, right? So
there's limits on that one.
Yeah. So obviously there's an ability to look at the right to bear arms as being like unlimited or whatever, and that's not what the Second Amendment did. And we know that because when we look at the founding of the country, murder was illegal still, even if you used a gun. And so when we do that, if we look at other rights in that same way, that right that was codified in the Second Amendment already existed. It says the right shall not be infringed, and Chance made this point earlier. So that right that existed from the nation's founding and before shall not be infringed by government. That was the end of my point.
Oh, okay.
Yeah.
The next question that I have just generally about this speech is whether or not it is appropriate for the justices to be coming out and making these kind of statements and laying out this legal philosophy. Mm-hmm. Or should we be kind of putting them in their black robes without collars and putting them in the back room until a question or controversy, a case or controversy is presented, mm-hmm. and then at that point they can opine only in the form of a written opinion about how they feel about certain things?
I mean, I think historically justices have done things outside of whenever they're sitting on the bench, particularly in academic institutions. This is, Supreme Court justices have historically taught classes.
Yeah.
As a matter of fact, the first Justice Wilson, going all the way back, he did his lectures on law that actually built out the first law school curriculum of an American law school. So
which we still cite to this day.
Yeah, we still cite. So this is something that historically justices have been involved in. But there is a line, right? And this is something that we hear in confirmation hearings all the time. You don't want to prejudge individual cases. So, if Justice Thomas was talking about particular cases coming up through the Court of Appeals, and he was expressing his views on those cases, I think that there would be some problems with that. They would give you're basically previewing how you're going to rule before you rule. But, I mean, Justice Thomas can talk about John Locke, right? Like Justice Thomas can talk about the distinctions between John Locke and Mao or Marx or these other philosophers. And I think that's fine. I mean, we have a long history of justices, in academia making these sort of academic arguments. And I don't think that there's a problem with that.
If anything, it helps those of us who are practicing under those justices understand a little bit better what it is that they are looking for,
right,
and helps us understand where their legal positions are going to come from in the end.
Yeah.
Not necessarily in like a predictive case-by-case basis, but at least to help us understand which direction the law is moving.
Yeah, this is not someone who's going out and campaigning for a political candidate. This is not someone who's going out and actively engaging in the political discourse. This is someone who is going out, who is an expert in his field, going out and talking about the Constitution and talking about political, philosophy.
Which is sort of why, go ahead.
Supreme Court justices in the past have done that.
Yeah.
They've endorsed presidential candidates and stuff going way back. So the idea that what Justice Thomas is doing, which is talking about founding principles, is somehow out of bounds, that's missing the mark.
I mean, Justice Rehnquist, I believe, wrote a book on the impeachments of 1871, right? I think that was, this is like justices talk about history, right? This is something I think is within bounds, as long as you're not talking about specific cases and specific fact patterns and specific claims that are coming before the court. And I think that you just have to balance that if you're a justice on the court.
But it's not something that Congress has the ability to step in and say, here's what you can say and here's what you can't say, and if you don't, these are the parameters. I suppose that's a different question entirely.
That would raise all sorts of separation of powers and First Amendment problems.
We'd have so many issues if we were to do it that way.
Yeah, but that right was given to the justices by the First Amendment. Sorry, I had to do it.
So Congress can do whatever they want to with it. The kind of last observation that I had on this is just kind of the discourse around all of these statements, the extent to which the media on both sides has sensationalized this particular speech. I don't know about you guys, but my impression of it in the moment was this is a really solid, well thought out, history speech. Like this is a speech about history. This is a speech maybe to a certain extent needling, like I said, those conservative listeners and justices that tend to be a little bit more Burkean in their approach. But like other than that, it was pretty restrained in my perspective. But the media has taken this and thrown like Justice Thomas trashes been, you know, et cetera, et cetera.
Media gonna media at some point. This is one of those things that you want to have the hyperbole in our polarized time. You get more clicks if you have a sensational headline. But also, too, there's a part of it that the left, I don't think, likes to be reminded of the connection of the progressive movement to Mao and Stalin and Hitler and the eugenicist, right? Like the American eugenicists were in a lot of cases, on the American left, and they came out of the progressive movement.
They don't want to hear about Buck v. Bell.
Yeah, they don't want to have that conversation. And I think it's a conversation that's worth having. It's not that you're saying that anyone who's, you know, to the left of Ronald Reagan is Mao, right? But, you know, at a certain level, you have to say, like, these ideas come from a place, right? And you should have to deal with that history. And I don't think anything that he said was out of bounds, but I think that's where a lot of this outrage comes from. One, media just wants something sensational. And two, I think they got frustrated by having to, you know, on the campus of the University of Texas, have those ideas put before them.
Yeah.
Let's mention, you mentioned Buck v. Bell.
Yeah.
He goes into Buck v. Bell briefly.
Justice Thomas does.
Yeah. If the criticism is correct and our rights come from the text of the Constitution only, in Buck v. Bell...
I want to push back on that.
Yeah.
It's not that it's that the rights were granted by the text. Like the text is the enumeration of the right when you're a judge. But the idea that government granted the right and the text isn't just recognizing a pre-existing right is what they're saying.
Yeah. So, thank you for that clarification. So, in other words, if only the enumerated rights are all we have, is what some of the textualists would say.
And that they come from government, and they're not a recognition of a pre-existing right.
Yeah, so they flow out of government. Government gave us our rights, and therefore there couldn't be pre-existing rights.
Yeah.
So in Buck v. Bell, a woman was forcibly sterilized. And the court upheld that, and this is what Justice Thomas was referencing in his speech. The court upheld that. The opinion actually states that three generation of imbeciles is enough.
Right.
That if you believe that your rights flow from government, you will not find anywhere in the Constitution that says that you can't be sterilized against your will. That's not one of the amendments of the Constitution. That's not in the text. So why is Buck v. Bell wrong? Why can a woman not be sterilized against her will if society deems that that's proper, that we don't want to have another generation of imbeciles, to quote the court? Why would sorry, I lost my train of thought. Why is that wrong? Why can we not sterilize people against their will because there's no right against it in the Constitution?
Yeah, absolutely. I want to circle back a little bit to something you said a minute ago, Chance, about how certain justices on the court don't necessarily want to... this is the wrong way to phrase it. Certain justices on the court think that it's not their position to reckon with the downstream consequences of an opinion that they make. Mm-hmm. And so next I want to talk about a situation where the court has to reckon with the downstream consequences, and that is the so-called shadow docket. So this week, the New York Times published an article talking about the shadow docket and what it declares is the birth of the shadow docket in 2016. I believe the case was Mass v. EPA. I should have checked that beforehand. But
no, it's the Clean Power Plant.
I'm sorry,
case.
It's a Clean Power Plant case. And there's a leak from somebody in or around the Supreme Court showing these memos back and forth between the chambers of the justices debating whether or not they should grant a stay of the Clean Power Plan. And first, I want to talk a little bit about the shadow docket itself. So what is it? We've talked about this in the past briefly. What is it? How does it function? And kind of why have we gotten to this place? And then we'll talk about the New York Times article itself, and then we'll go a little bit into whether or not we think that this is a good thing in the long run. So, Chance, what is it? What is a shadow docket, and is that really the best term for it?
Yeah, I mean, it has a lot of names: the shadow docket, the emergency docket, the interim relief docket, and really, what it is when someone runs up for emergency relief. So, in many cases, someone has applied for an injunction to stop a government action at the district court, and they've lost, or and then they run that up to the Court of Appeals sometimes, though not always, and they lose, and sometimes then they run that up to the Supreme Court, and they're asking basically the court to grant an interim relief, to basically pause the government action, right? Or to allow the government action to go into effect, depending on whether you're the winner or the loser, while the case is decided. The shadow docket or the interim docket is really just deciding what the status quo will be while the case is litigated, because litigation can take years.
So I'm going to put some flesh on this so that we can kind of talk about this in terms of a hypothetical, because I think that referring to this in the abstract is sometimes difficult for people to grasp. So if we had a case where, we've got a tree in the city of Austin, and the government says you have to cut down this tree, and the person who's suing the government says, no, this is my tree. I don't want to cut down my tree. You can't make me cut down my tree. I have a right to my tree.
Yeah.
And the city of Austin says, well, that sucks. Go up to the court, the district court, and say, I have a property right in my tree. The government can't force me to cut down my tree.
The Supreme Court would never take this on the shadow.
Absolutely not. Absolutely not. But the question that then becomes, while we are deciding at the district court level whether or not the government gets to cut down my tree, does the government get to cut down my tree in the meantime?
Yeah.
If the district court says yes, the person who owns the tree can then take it up to the circuit court, and the circuit court can say, no, while this pens, because, it's a 110-year-old tree. If you cut down this tree, you're never getting it back. Okay, they can't cut down the tree while this litigation is pending. We can bump it then. Okay, well, let's appeal that decision up to the Supreme Court. Can you cut down my tree? Supreme Court, government wants to cut down my tree. Can they cut it down while this is pending? That opinion that's decided at that juncture is what we refer to as the shadow docket.
Right, that is. And I think it's important that this is something that you had seen a long time in death penalty cases, for example, for that very reason. You can't unwind certain things.
Right. Once someone is dead, you're not unwinding that.
So these appeals would go up, and they're not decided on the merits. The court just is deciding what the status quo will be. Oftentimes, they're decided without oral argument, though not always. Oftentimes, they're truncated briefing. They're decided without a written opinion. Sometimes there's a written opinion. Sometimes there's not. Because, again, this is emergency relief granted to just determine what the status quo will be while the case goes forward.
And we do sometimes see where we've gotten all the way to some sort of injunction from the district court before we even get to these circuit courts on the circuit court and the Supreme Court on the emergency docket. So sometimes you do have a district court decision, and then we're appealing to say, can you cut down my tree while the circuit court opinion is pending?
Yeah.
That does sometimes occur as well. But I think at least in the last 10 or 15 years, the majority of these cases have been at the district court level, whether or not you can cut down my tree while that opinion is pending.
Yeah. And we've seen decisions like from the Fifth Circuit where they have like a motions panel where they'll just look at, and the courts are really, especially the appellate courts in certain situations, are very agile and able to hear these cases pretty quickly. Where
what do you mean by quickly? Because your definition of quickly in the average Americans might be a little different.
Yeah, okay, fair enough. So like within weeks or months versus the 2, 3, 4, 5 years it can take to get to the Supreme Court and get to final judgment. So like there's been numerous cases that have come through where the court has decided in a couple weeks based on, like, say, a district court grants an injunction, and then the Fifth Circuit would hear in a motions panel just whether or not that injunction should stay in place while the case continues in the district court. And then if whoever loses at the circuit court could then appeal to the Supreme Court. And so you can get this very narrow holding from the Supreme Court within a few weeks or a few months, which is important in the situation that you just demonstrated, where harm could come to someone if they don't have a pause of what's going on in the interval.
So is the term shadow docket a term that the court came up with, or is it something that America generally has decided that we're going to call this?
Was it Will Bode that came up with the term shadow docket?
It might be. That wouldn't surprise me.
I think it might have, but it was a commentator.
It was a commentator. This is not what the court's referring to this as, because there's nothing secret really about this docket. Yeah. These appeals are public. You can go on the Supreme Court's website and see all of these filings. These requests are not, they're not hidden in any way. Sometimes you hear this referred to as the emergency docket, but that's not really appropriate either.
They're all published. It's all public. It's not secret. The reason the reason the term shadow comes up is because oftentimes there's no oral argument, and oftentimes the opinion isn't. Oftentimes the judgment on the shadow docket to keep an injunction in place or lift an injunction isn't accompanied by a fully written opinion. Sometimes it is, but oftentimes it's not. And so because of that, they say that there's some secrecy to it. But it's not secret in the sense that like no one knows that it exists. It's very public. But you lack the sort of transparency into the process and the reasoning.
But there's other situations where we also get decisions without reasoning.
Yes.
And so it's not accurate for that reason to call it the shadow docket either, because then you'd have to say every time that we have a grant, vacate, remand decision, which happens fairly often, that's also shadowy or something like that.
What is a grant, vacate, remand decision? Just like 10,000-foot view, what is that?
Yeah, so the Supreme Court gets a case on review, and they say because of some other case, usually it's one sentence or two sentences, that either the district court or the appellate court got it wrong, consider it again. And so we're talking like one sentence, maybe two sentences, and it's back at the district court level, and they've just said do-over.
So it's pretty much a pure error correcting function. It's like, okay, guys, go read the law again. Try again. You were wrong.
But if there's no reason, if there's no reasoning, then why is that not a shadow decision also?
I'll do you one better.
Yeah.
The court takes less than, was it 2% of cases?
Yeah.
So the overwhelming majority of cases, like 98% of cases, are just denied review. Like someone appeals to the Supreme Court, the Supreme Court denies review, effectively leaving the lower court opinion in place, whatever it was, and there's no reasoning on that at all. So for years, the overwhelming majority of cases don't have written opinions.
Yeah.
Right? And so that's not really, but that's one of the objections, right? Is you don't have this insight. I think let's go back to the article, because I think the first thing we have to say is the New York Times says that this is something that's new. So that's the headline.
This started in 2016. This is a whole new thing that Chief Justice Roberts invented because he didn't like Barack Obama, which is like 9 different claims all in a row.
And so I think
need to be handled.
I think that's the first question. It's like, is this something that was created in 2016? Do you have any?
Yeah, is it
Nathan,
though?
I feel like you did some research on this because it was a bee in your bonnet. Tell us about the bee in your bonnet.
So when I read that, it struck me as odd that they would make this claim. And so when we research, we realize that the Supreme Court in some fashion has been granting a relief before final judgment in an appellate court, almost going back very far, hundreds of years, or over 100 years. So, but the reason that it is even able to do that was decided by Congress. So Congress in 1925 kind of passed the act that gave us more or less the modern judiciary as we look at it right now, and it allowed a process called certiorari before judgment, which is that the Supreme Court can review a case before an appellate court has rendered a final judgment on that case. And so that's still on the books today. It's 28 U.S.C. 2101E.
But shadow docket cases, they haven't granted cert before judgment. That's a separate procedure, right?
Fair enough. But this actually does more than what the shadow docket cases do, because certiorari before judgment actually decides the case.
Yes.
So as we talked about with the interim docket, I don't like calling it the shadow docket. I don't like that. But the interim docket, the interim docket allows for a temporary pause, but a certiorari before judgment decides a case finally. And the court's done that going back for years. But if we want to look at just the shadow docket, which is what Chance is asking for, in 2014, we had a case of an abortion law that went up from Texas. And
an anti-abortion law specifically.
Yeah, prohibiting abortion that came up from Texas. And the court, it went on a preliminary status, an interim status, went before the Supreme Court, and the Supreme Court stayed the enforcement of that law while the appellate process was ongoing.
So and 2 years.
And it's interesting because the breakdown of that, Justice Kagan and the others on the left side of the court were in favor of that.
Yeah, it's interesting. It's interesting that it was basically it was the 3 more liberal justices along with some of the more centrist justices on the court. Granted that, I think it was 6-3 on that case to grant the relief. So it's interesting that then they flip like a couple years later and basically say that, well, we would never grant relief in this position, but in 2014 they were okay with it.
But if you're the New York Times, like, that's not even hard. That's 2 years. That's 2 years before this thing was allegedly invented. You don't have to go back to the Judiciary Act of the 1890s or the 1920s and talk about cert before judgment. This is interim relief on a shadow docket before the shadow docket in an abortion case, a highly charged political case, 2 years before it was allegedly invented by Justice Roberts to stop the Clean Power Plan.
I think it's important, too, to look at what was happening in that era. So the New York Times article kind of posits this as like this is a big shift in how the court operates. But there were a lot of big shifts happening in that era between 2014 and 2016. We have Barack Obama doing all kinds of unprecedented things. Yeah. And so, of course, the court is going to have to turn to some unprecedented, maybe-ish, means of handling those things, because if they start cutting down 100 trees, the court is going to start taking 100 cases, if you will.
Well, those are two separate questions. So I think there's one question about, did this sort of interim relief exist before 2016? And 100% it did, full stop, period. It is not debatable. This type of relief.
This is a question of historical fact.
This is a question of historical fact. The court did this before. As a matter of fact, we were talking earlier, you have a case in the 1950s that's like a one-sentence opinion.
I think that was a cert before judgment, but still, yeah.
It was. So in 1959, the United States v. Haley, the Supreme Court reviewed a district court decision, skipped the appellate review process entirely, and they reversed the district court. So, and this is not an interim status. This is final judgment. District court, you're wrong. Do it over again. And so like that's in 1959. Going back before that, we can go back into the 1890s and early 1900s under a different process where lots of cases under the Judiciary Act of 1891, lots of cases, like especially adjudicating constitutional issues, could bypass the circuit courts. So this is not this idea that the Supreme Court getting involved before we have a full dissection of the opinion in the appellate courts. That's been going back for a long way.
So that's one part of it. It's like, is this a new procedure? And the answer to that is just no. This was not something that Roberts made up for the first time in 2016. There's a separate question about the amount of times it's being used.
Right.
Right. And so we do, in defense of a lot of folks, there are a lot of things now running up on the emergency docket or the shadow docket or the interim docket for interim relief. But that also ignores the chain. And that does kind of start in the late 2000s. You see more and more of that. But there's also an important thing that happened at the same time, which is the idea of pen and phone legislation from the executive branch. You know, Obama finally, he famously says that I have a pen and I have a phone and I don't have to go through Congress. So I'm going to make national legislative policy through the executive branch that's going to be locked in immediately. And those things are challenged and those things are running up. And it doesn't stop with Obama.
No.
The first Trump administration expands on that. Then the Biden administration expands on that. And then the new Trump administration expands on that. And so you have record numbers of executive actions making nationwide policies circumventing Congress, and people understandably are running these things up. And so I think to separate those two things, one, there's a historical thing. It's not new. What is new is the number. But it's not like the court has taken it upon itself to just start reaching into all of these district court cases.
And nor could they if they wanted to.
Right.
They don't have the authority to just grab a case and say, this is the one we want to hear. I mean, even in the case of the cert after judgment, you still have to petition for cert. You still have to request this relief from the court. It's not something that the court is just going to throw at you because this is what they like doing, And we've ended up with calling this a docket in some way, as if it's something that the court has set aside and we're going to take 19 cases off of our emergency docket. It's saying no, here's 19 things that we have to handle right now because these are the 19 things that the president did this year. And that's a different question entirely than is this new or is it different?
So some of the problem that we have is just that the court is having to deal with things like this because we have congressional deadlock, and that things that should be done really by Congress are being done either by the president and maybe in a questionable circumstance. And so if Congress was able to pass laws more frequently, then a lot of these things wouldn't need to be run up in an emergency status because an executive order can take effect immediately, whereas Congress is more deliberative.
Absolutely. Which kind of leads to my last question of the podcast for today. In general, is the shadow docket a good thing? Is this interim docket a good thing or a bad thing? Because I think there's some tension that exists in this problem, especially the way that we've framed it, which is that on the one hand, we get this interim decision makes something happen, right? It protects the tree from being cut down by the government. Golden. However, this is done on a truncated basis with minimal briefing, often with minimal sets of facts. There's a sense of the justices are doing something in a underhanded kind of way, even though it's not what's happening. That's the sense that the public has, and so it erodes public trust a little bit. So holding those two things that are in tension out against each other, do you think, both of you, do you think this is a good thing or a bad thing, and how would we change it? What's the alternative?
I mean, it sucks that this is where we are. I think that the fact that there's so many things that are being run up on the emergency docket is bad for, our political system. But I do think it's worse because of the way the media covers it.
Yeah.
The partisan way that the media covers this, the unfair, like what we see in the New York Times, where they're actually saying things that are factually untrue about it to make the court seem partisan, to make the court seem more aggressive than it is, to actually attack the court is a problem. Because our nation functions based on the idea that there is this neutral arbiter that you can go to, the court, to decide these sorts of disputes and do so neutrally and fairly. And that's really what makes all of the other branches be able to function, is that we believe that there is a referee that we can go to and get a fair adjudication. And the fact that the media attacks it and tries to undermine it for what I think is political purposes because they don't like the outcome of some of these cases, I think they're playing with fire.
Yeah.
I think in the long run, it's playing with fire to undermine the legitimacy of the court that way. And that's exactly what the coverage here is. If you had the context that, hey, this is something that's happened for a long time, I think everyone would be mad at the executive branch for doing so much. People would be mad at Congress for not exercising their role in lawmaking. And instead, they're trying to focus the anger on the court and make the court seem illegitimate. And I think that's dangerous.
Absolutely.
And it's because the more they can politicize the decision making and force these like you're either a good guy or a bad guy to the media onto the justices, they're really trying to force the justices to abandon their principles and their legal reasoning and stuff like that, and to create the outcomes that they want. And the judicial branch is supposed to be the most resistant to those political influences. That's why Supreme Court justices are appointed for life, is because we don't want them to be influenced by the politics of the day. That's for the Congress, that's for the president, but for the Supreme Court, we want them to resist political influence and make a decision based on what the law says and what the law is, not what outcome they want.
And at the end of the day, what's the alternative? I mean, how else are we going to decide if the government gets to cut down the tree?
Well, I mean, the alternative seems to be that you just, but again, it's inconsistent in the way they report on it, because one alternative is just, well, we just leave everything in place. And so it's sort of the government always wins. Like the court's not going to intervene, and you have to just play this out for 6, 7, 8 years sometimes as a plaintiff. And if your tree gets cut down in the meantime, too bad for you.
Now the case is mooted and the court doesn't have to deal with it.
And this is one of the things that actually, if you look at the New York Times reporting on this, when they had the memos from Justice Roberts, one of the things that he pointed out was that at the time, the Obama administration had publicly stated that, it doesn't matter if 3 years from now the court finally adjudicates this, we will have already locked in everything we wanted by that time.
Yeah, the states will have already done what we wanted them to do.
Yeah.
It'll be done.
It'll be done. And so it's basically they were publicly saying that they were going to neuter the court.
Right.
And I think that's a problem. I think that's a problem. And so that's one way, is you just leave everything in place.
I want to in case it wasn't clear, Obama was publicly saying that he would have gotten everything he wanted if the court went through the normal process.
Yes.
And he lost. It wasn't, the court wasn't saying that they would get, but they want.
Yeah. And that was one of the reasons that Justice Roberts said that they had to intervene in that particular case.
Yeah. So at the end of the day, we have this New York Times article that's not being maybe the most honest with the American public about what's going on, but the situation being what it is this is how it is. These are the rules that we're playing by right now, and maybe at some point the court will change its procedure and its posture, but for right now, this is how they are protecting those rights that Justice Thomas pointed to in his speech and keeping us as free as we can possibly be. So
I would defend the shadow docket. I think that we need the Supreme Court to intervene. When you have an appeals process that can take 5 years, the Supreme Court needs to be able to intervene and pause things for the time being. And we talked about, otherwise, the government always wins. We're a little biased here against that government always wins philosophy, but I think that the American people should also be skeptical of the government always wins type philosophy, because when the government is doing something, if it's infringing on your rights and they just get to win for 5 years while the case is pending, then you lose your tree, or you lose your freedom, you lose your money, whatever it is that the government is regulating in the interval, and you should at least have the opportunity to go to the Supreme Court and say, Supreme Court, can you please just pause this adjudication while we determine what my rights are?
Yeah, absolutely. So I think that brings us to the end of our Shadow Docket today. If you've enjoyed our conversation, please leave us a review and tune in next time for more Rightly Decided.